Liquidated damages. According to Professor Dr. Chong Mei Fong in Contract Law in Malaysia, the legal definition provided is a fixed, contractually agreed upon sum of money which is payable by the defaulting party upon breach of contract. So what does this mean? It means that parties that sign a contract which agree that a particular sum is to be made payable by default by one party to the other party, such a sum is then referred to as liquidated damages. However, liquidated damages is only valid on two accounts. The first is when the sum that was agreed upon has to be a reasonable measure of the probable or an actual loss in the event of a breach in contract. Secondly, the actual loss suffered is difficult to be precisely determined by court. Therefore, by virtue of Section 75 of the Contracts Act 1950, it governs liquidated damages which provide that there is no need for actual damages or loss to be proved for the aggrieved party to receive the agreed amount. However, the case of Bhai Panna Singh against Arjun Singh and others has proven otherwise. It was held that the victim had to prove the actual damage suffered in order to claim compensation. Furthermore, if proven, the victim may recover the loss, but the compensation cannot exceed the sum agreed by the parties in the contract. Besides, the view of Malaysian and common law on liquidated damages are not the same. This is because the Contracts Act 1950 does not distinguish liquidated damages and penalties. In SS Maniam against the state of Perak, it was held that there was no difference between the two in Malaysia. So what are the requirements to claim compensation in the liquidated damages clause? It is expressly stated in Section 75 of the Contracts Act that the party complaining of the breach is entitled whether or not actual damage or loss is proved to have been caused. Many cases have their own views on the subject matter, and it can be concluded that proof of damages are needed as to avoid unfairness, such as a party claiming an amount much higher than the actual loss suffered. The issue of whether the practice of contracting out of statutes is against public policy. In the case of Oi Boon Leong and others against Citibank, the Privy Council suggested that the parties may contract out of Section 75 of the Contracts Act. Lord Brightman held that if freedom to contract is to be curtailed, the prohibition ought to be expressed in the statute. However, if the more recent case of Johor Coastal Developments, Arifin Zakaria, federal court judge, was of the opinion that contracting parties could not contract out of this section. He explained that he could not find any cases and specific provisions in the Indian Contracts Act which allows contracting parties to contract out of contract. Therefore, being the most recent precedent, it can be concluded that parties entering into a contract are not entitled to contract out of the provisions of Section 75 of the Contracts Act 1950. Finally, does the liquidated damages clause bring more harm than good? The liquidated damages clause are positive in nature because it allows parties to precisely foresee the costs involved in breaching the contract. It also allows parties to negotiate damages while preparing or drafting the contract. It also ensures that the parties will not withdraw the contract empty-handed, as they will either receive the agreed upon performance or receive the agreed upon damages once the contract is enforced. Therefore, we are of the opinion that liquidated damages brings more good than harm. Thank you for watching and have a nice day.
Created using Powtoon.